I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are walking into number 166 on our compilation list. And I just want to say I'm excited because you guys are excited about us going up to 200. I've been seeing everything that you guys have been saying in the comments, and I just want to say thank you for the encouragement. Today we're going to be in 4 different judges' courtrooms. Before I give you the rundown on those judges, don't forget, we will have commentary in some of these proceedings. Also, chapters will be added for your convenience. And don't forget to like, comment, as always, as you guys have been doing, like and subscribe. And listen, let me give you the 4 different judges' courtrooms that we're going to be in on today. And we're not going to be in Michigan on today, which it's very hard not to be because so many sovereign citizen proceedings happen in Michigan. But the first judge's courtroom we will be in is Judge Edgerton out of the state of Georgia. Second, we will be in the courtroom of Judge Lall, also out of the state of Georgia. And third, we're going to sneak in another Texas judge that did not make the proceeding the proceedings that we shared recently, where we did the all Texas judge compilation, and that is the famous Judge Stephanie Boyd is in this compilation out of the state of Texas. And last but not least, we have also out of the state of Georgia. Listen, guys, it is always a pleasure for you guys joining me here on Sovereign Citizens Hall of Fame. Now, let's go ahead and jump into 166.
All right, Mr. Chung, you are here on position 21. We have Mr. Williams here. I know we have our virtual calendar that we are in the midst of. And what exactly do we need to address today, Mr. Williams?
Judge, we need to set down for trial and have rent paid into court.
Okay. And so I have your answer, Mr. Chung, which says you don't owe money to the landlord. See attached defendants, defense's answer and counterclaim. So you've attached these documents. Is that part of the motion to transfer?
That's correct, Your Honor. My defense is that... Oh, okay.
Go ahead.
My defense is that this court lacks jurisdiction. I filed a compulsory counterclaim for $58 million based on systemic fraud that renders the lease void ab initio. Under OCGA section 15-10-45, subsection D, because a counterclaim exceeds your $15,000 limit and arises from the same transaction as the eviction, this court must transfer the entire case to the Superior Court. I respectfully ask for the transfer order. I'm prepared to pay the transfer costs immediately to expedite the process.
And Judge, we would oppose any transfer of the case. He's going to have to make a probable cause showing.
Well, yeah, let me hear from him first. How did you arrive at that very specific number of damages?
So they were acquired by Blackstone. So 1% is the standard for a deterrent for any sort of punitive damages. Blackstone they acquired them for $5.8 billion.
Okay, that has nothing to do with you. So what are the damages that you sustained?
The systemic fraud. Also, respectfully...
What fraud?
Your Honor, have you had the chance to look at the exhibit list?
I see the exhibits that are here. So what exhibit would you like me to direct me to that deal with particularized damages that you have experienced and endured?
Well, Your Honor, respectfully, these merits and arguments regarding the fraud claim, this court lacks the jurisdiction to weigh that evidence. So that's
not your decision to make. You can't just slap a number on a piece of paper and get it sent to whatever court you want. There has to be a showing that there is a substantial basis for the claim that you're making and the number you've chosen. And so what I'm asking you is what is in your documents that I can look at now to help understand that.
So if we look at exhibit C.
That was B as in boy?
C as in cat.
C as in cat, I'm sorry. All right, one moment. I have that loading now.
So I got a dismissal order for the prior dispossessory warrant, which is failure to properly serve the defendant, which was dismissed without prejudice.
That was signed by Judge Block around December 3rd. I see that.
That is correct. And then once we move to Exhibit D, we see the satisfaction of judgment on the same case that was dismissed. You see where I'm going, Your Honor.
Okay. And how does that damage you?
I haven't spoke to the counsel or attempted to speak to them because I was willing to reasonably come to a solution. I told them about home ARP, which they have recommended themselves. Okay. And because of this chaotic filing, which is also, if you look at the signature of Abby Hart and the signature of Abby Hart from Exhibit D.
I'm asking you one more time to explain to me how this has negatively impacted you. The case was dismissed and there were documents reflecting that you did not owe money. What I do not yet understand is how this has negatively impacted you in an amount that is roughly 50,000 times the amount of the money that was in question.
They have sabotaged me from getting home ARP. This is a bigger case. Once again, Judge, I'm telling you, this is out of your jurisdiction. If you want to dismiss it or whatever you want, it's going to be appealed. Okay, I can't speak any further on it. So I just want it noted for the record, because this court lacks subject matter jurisdiction over the counterclaim. Any ruling other than a transfer violates OCGA section 15-10-45 subsection D and prejudices my rights in superior court.
So your claim is that you were deprived access to the home ARP program because this case was what, either pending or incorrectly recorded or both?
Respectfully, Your Honor, there's nothing more I need to say. The merits and arguments regarding the fraud claim, this court lacks the jurisdiction to weigh the evidence. So the entire case must be reserved for the superior court.
This court disagrees, and we will see you at trial. Your court date is going to be December 29th. You are to come with any evidence, witnesses, or arguments that you wish to present regarding the case in chief and any subject matter that you claim. The court at that time will take a further evaluation. Whatever claims you are asserting. And in the meantime, the amount of rent that is alleged in the dispossessory warrant, which is loading now, is $2,534, spanning the months of December and November of this year. Do you agree or disagree? Do you agree or disagree that those monies are still owed for those 2 months?
Well, I'm not admitting to the ledger, but to prefer the status quo, I'm willing to pay. But I do want to tell you, Judge, if the case was dismissed and if the satisfied of judgment is on there, it clearly shows you right there the fraud. So if that is what you need to pay into the registry, I'll immediately gladly pay that.
So I will make it clear, any money paid in the registry is held in the registry and dispersed to the appropriate party at the conclusion of the case. And so any payment into the registry does not presuppose that they are entitled to that money or will receive that money. Just out of, in the interest of clarification, what I can tell you is that if they have accepted any money after the filing of the case, then the case must be dismissed. And so the fact that there was a satisfaction of judgment or a dismissal on a previous case does not necessarily mean that everything was paid in full or that there wasn't an outstanding balance. That money could have been money that was owed for October, for example, but November and December were still owed. And that would be something they would have to prove at trial if they were going to seek those damages from you.
That's absolutely correct.
But in the meantime, thank you for letting me know that's correct. I appreciate that. And in the meantime, the payment of rent into court is going to be the 2 months as alleged, and the order again will designate that all of that money will be held into the registry, held in the registry pending resolution. And so let me zoom in to make sure I can read the tiny font correctly. $12.67 per month. It will be $25.34 with ongoing payments of $12.67 per month every fifth of the month thereafter. It will be in courtroom 1200C. If there are any witnesses that you need to handle any portion of this case, please have them with you present in person. If there are any evidence or any pieces of evidence or exhibits that have not yet been turned in that may need to be addressed, please either have them electronically submitted in advance or have them in a physical or electronic form that can be turned over to the court. So that would be something like a CD, a DVD, or flash drive, as opposed to something still in your photo gallery, just to use an example. And so one of our judges will see you on December 29th. And you should be ready to proceed on any issues that you wish to litigate or need to litigate at that time. Do you have any questions?
The only thing I have to say is, once again, I would like my objection to be noted for the record, because it's
so noted.
Awesome.
All right. I will prepare that rent into court order. Mr. Chung, I'm guessing since you've submitted electronic exhibits, we do have an email address on file for you. Is that correct?
That is correct.
All right, we will mail that rent into court order for you. That payment will be due by Friday the 26th, and then court will be on Monday the 29th in courtroom 1200C of the DeKalb County Courthouse. That C is in cat or Charlie, and we will see everybody there.
All right, thank you, Your Honor.
All right.
Thanks, Judge.
Thank you. All right. I have two more cases on my calendar. Courtroom 2, who do we have next?
We have position number 12, Mr. Sparks.
Oh, three more cases. Okay. This is Mr. Lewis Sparks, accused of a violation of the law regarding squatters, 16-7-21.1. Case number is 25 CR 000147E. Offense date appears to be December 20th, 2024. Now, Miss Franklin Brennan, did you get that phone number that was sent to everyone? Okay, thank you. Okay. Mr. Sparks, you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is going to be Mr. Michael McLean. Any priors?
Well, no squatting or history. 2024. He got an open case, ag assault, crude 10 to 3rd, criminal damage to property, 2nd degree, obstruction, simple assault. It's 24 PI 002815. Open theft by conversion, 22 SC 182232, 2018 FTA.
Miss Allen?
Thank you, Your Honor. This is an incident from December the 20th. There was actually a hearing in magistrate court in front of
Judge Ashley.
Judge Ashley on the 7th. He found probable cause for a count of squatting. The owner of the location at 5558 Union Point Place in Union City had to do a private action for a warrant because the defendant refused to leave the premises. He's filed in a bunch of sovereign citizen, UCC, gobbledygook, and has an AKA. The victim in this case is Mr. Douglas Walls, the owner. Judge Ashley issued a $10,000 good bond after hearing on this matter. I would note that the open 24 PI case mentioned by pretrial is from April of 2024. The defendant in front of you was released on bond following his arrest in that case. And as part of that bond, he's been ordered to stay away from the location. That's the location where his wife and his 5 children live. And the case in Superior Court is an aggravated assault against her in front of those children. So not only is he fighting to stay at the property, even though he has no legal right to possess or be on the property. And the owner of that property had to go through the court system to get him out. The court has already ordered him to stay away from that location because of the open felony aggravated assault. We're asking to keep that $10,000 good bond that Judge Ashley put in place. I'm guessing it was for a reason. It might be part of the 60 pages of things that have been filed into this case and the gobbledygook and someone who just frankly refuses to acknowledge that they've been ordered to stay away. We will continue to try to be in contact with the victim in that 24 PI case, Your Honor, Mrs. Duncan, and I've already alerted the DA's office that this gentleman is now back in jail for a violation of the bond in that case. And so that's where we are. We'd ask for no contact with the gentleman who owns the location, Douglas Walls, or anyone else who's living there, to stay away from 5558 Union Point Place in Union City. No drugs, alcohol, or weapons. Thank you.
Mr. McLean?
Your Honor, my client, Mr. Sparks, is a high school graduate. He has been working in the ministry for a year and a moving company for 8 years prior to that. Based on the charges, he's also been in Georgia quite some time, over 11 years. He's 42. Your Honor, based on the charges, we understand what the state has been concerned about and is concerned about. We would ask the court to consider a signature bond, and if not a signature bond, then something like a $1,000 or $2,000 surety.
It's going to be a $5,000 surety bond. I'm not sure whether he's got a bond surrender in his 24 PI case 002815. I just see some notes about that, but y'all can look into it.
I didn't see that he had a bond surrender. It's just real clear he can't go back to that location as a condition of his bond. It's a $20,000 good bond, I believe.
Okay. But meanwhile, it is a $5,000 surety bond for this particular case to stay 500 yards away from 5558 Union Point Place in Union City, 30291, to have no further contact with Douglas Walls, no illegal drugs, no alcohol, and no weapons and no firearms. And his next court date will be January 21st.
$5,000 bond.
All right, the court, and I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, Arlene Bay is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, and defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're going by third party,
Okay.
and I'm not. I don't. Third party, I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bear County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand?
I understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mm-hmm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel.
Mm-hmm.
Right, Mr. Beltran, that's not to be heard right now?
All right, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mm-hmm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute or natural person, it is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay State Bar dues every year. And when that comes around every year, everybody's like, oh my gosh, State Bar dues.
Student.
Yes. So the State Bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir.
All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false State Bar, anything with regards to the State Bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this offense.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection, Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, sir.
All right, does that address that issue?
Yes, sir.
I think the other issues deal on the second page deal with the state bar, and I think the courts addressed that.
Okay.
The other one is the gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, sir.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is that something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right, so if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, ma'am.
Oh, you're welcome.
Well, guys, we have come to the end of this proceeding. Judge Boyd definitely handled this situation well. It wasn't really a whole lot to say about this because there wasn't really much of a fight from Mr. Beltran. I want to say he's smart by using an attorney, but in the way that he used his attorney, I can't quite say that because basically, she adopted his motions, argued them for him, which I was surprised to see because I have never seen an attorney be willing to argue sovereign citizens' motions. A lot of times we'll see them back out or just be standby counsel and allow them to, argue their motions on their own. But for whatever reason, this attorney felt the obligation to do so. But I don't feel that Mr. Beltran used her obviously to the best of her ability, because by her arguing these motions that really, didn't have a leg to stand on in the courtroom, it almost was pointless. But if you really notice his reaction to when Judge Boyd asked him, does he understand? He's calm, it almost feels like he didn't really want to come to argue these motions. but he rather just that they be heard and that they be on the record, which we know a lot of sovereign citizens, that's very important to them, that whatever it is that they have to say or believe, that it is on the record. So once again, not much to say on this particular proceeding. We'll see what happens with the jury trial. As always, I appreciate you guys joining me here at Sovereign Citizens Hall of Fame. With that being said, don't forget to like, subscribe, share, all of those good things. It is much appreciated. And with that being said, guys, this is Sovereign Citizens Court. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. See you guys soon. And God bless.
All right, then we will go to Ms. Celestine's case. We will let the state be able to set up. There's very important issues today. Now we were on this, I'll just set the case up and then it's back to me.
All right. 23B 1593 etched in.
Okay. All right. Ms. Celestine, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Ms. Celestine would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. An examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the bond.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Lall. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol. And that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest made that was September 16th, 2025.
Right. So after the time she failed to appear in the court, did she have any other arrests other than this driving offense?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the bench warrant was outstanding. So we would submit to the court that based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any any bond conditions, she would just ignore. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Everything. Yep. Thanks. The address I'm showing is 2214 Upward Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Celestine, that is the issue before me is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond, reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she's saying that she won't have to come out, so I will bring her to you in person.
Okay, so she says she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, if she'll come out, I'm glad to hear it. It's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's an offer. Got it. Is it? No, it's not. We've had to get.
All right, so astonished for this. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authority of the court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. Right? I got to make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right. I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might still just.
Ma'am, you have a right to be heard on those issues, because that's the matter right now.
Okay.
If you don't want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
do you wish to respond to the bond criteria or not?
Well, first, the bond is excessive, and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protections under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights, and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retained rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to bond. Now we're back on.
I did give you Article
the 2 bond conditions, yes or no.
I gave you Article 1, Section 1, paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, Amendment 8, I should not be held under false imprisonment, under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. It's something else you're wrong about. But anyway, ma'am, I'm once again sad.
Can I judge his comments and opinions be posted on the record?
This is where I'll have you removed, because right now.
You might as well. That's fine. I don't care.
That's fine. But ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything to pay.
That's fine.
So
well, it's not for me because I'm not the defendant. I'm held here with the defendant.
Right. Take care, ma'am.
Under be corrected.
Make different decisions.
Make the rest of coercion.
All right. Take care.
I'm not threatening you. Say one more word and that's 30 days. 30 days.